Over the past several years, there's been increasing regulations that restrain employers' use of non-compete agreements. So the federal regulators have gotten involved and states have followed suit in terms of really taking that tool away from employers. So for example, the FTC this past year, they proposed a rule that would ban non-compete agreements and would ban that retroactively. And several states have followed suit. Minnesota passed a law last year that prohibits non-competes, and even California, which is a long-standing rule prohibiting non-competes, passed additional legislation that said effectively non-compete agreements are not enforceable, but they're not enforceable regardless of whether the employee signed that contract in California, and frankly, regardless of whether that employee worked in California. So California's legislative history is taking the position that California's public policy with regard to restraints on trade, non-competes, actually trumps other states' laws when employees are seeking to work in California, regardless of whether those other states had an interest in the employment. So one of the things employers can do is really evaluate on a state-by-state basis what types of restrictive covenants or contracts that still work. So for example, every state still says a non-disclosure agreement or a confidentiality agreement is fine. And even in those states that say we don't permit a non-compete anymore, sometimes they permit like a customer non-solicitation agreement, or maybe they have restraints on non-competes, like they have a salary threshold, or they can only apply to certain types of employees. If you're in a state that prohibits the use of non-competes, instead of just relying on a non-disclosure agreement or a confidentiality agreement, those employers should consider whether any new technology tools would help them protect trade secrets. There's a lot of software available, for example, data loss protection programs that help employers control and understand the data that's leaving their environment. There's also technology tools that help employers control data and information that's stored on the mobile devices of employees. And there's also technology tools that help ensure that the information that's on the network just never leaves the network, like encrypting a hard drive or prohibiting employees from sharing data to the cloud or with other people by email, restricting that type of use, and looking at their existing policies and making sure they're effective and that they're enforced. For example, when an employee leaves to a competitor, doing an exit interview, reminding the employee during the exit interview that they still have contractual obligations to not disclose, not use trade secrets or confidential information. Or perhaps if you're in a state that permits some type of restraint, you can't solicit customers. Another simple thing, collect your equipment. An employee is walking out the door, make sure you gather the company property like the computer, like the thumb drives, like the materials upon which employees store electronic data. Evaluating an employee's use of email before they leave, or their access to the network to see if there's been downloading activity or activity that suggests that the employee may be taking information with them that they shouldn't.